any evidence that even one...
Magandang okay. Natin ipresenta po natin sa ngayon yung first of the three presentations for today or the last day of the confirmation of charges hearing ng defense na ginagawa ni Attorney Nicholas Kaufman. So, i-play po natin, makinig po tayo at ating pong pakinggan kung paano. Dito po tayo sa malayong lugar. So, ito.
The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte.
Really assist you. Magandang gabi.
Please be seated. Veuillez vous asseoir.
Elma Reliosa, magandang gabi. From Hong Kong, Manny Elbao.
Judge Motok. Good morning, everyone.
Ryan Rodriguez.
I'd like to welcome everyone in and outside of the courtroom. Court officer,
Julia
kindly call the
Lawakan.
case.
Magandang gabi po sa inyo.
Madam President, Your Honors, situation in the Republic of the Philippines in the case of the prosecutor versus Rodrigo Roa Duterte, case reference ICC 0121, 0125, and for the record, we are in open session.
Berador.
Judge Motok, thank you very much. I would like to ask the parties and participants to confirm that the team composition is the same as yesterday's. Good morning, Madam President, Your Honors. I can confirm that indeed the OTP is represented by the same staff members. There have been a few changes over the days, but they are all here. The presiding judge, thank you very much, Deputy Prosecutor. Ms. Masida, for the legal representatives of victims. Ms. Masida, good morning, Madam President, Your Honors. Same composition as yesterday. Finally, the defense, Mr. Kaufman.
Merci beaucoup.
Thank you very much. I would now like to call upon the defense to address the court and to complete their submissions on the merits.
Dito tatakil niya si Kian de los Santos.
We have to
si
add
Mayor
the
Espinosa.
time that the defense did not use, but you can use all your time. We will have a break at 10:30, and then we will continue in the afternoon. So, Mr. Kaufman, please proceed, and you must respect the Chamber's decision regarding redactions. Otherwise, I will be obliged to interrupt you each time so as to protect victims and witnesses. Mr. Kaufman, please go ahead.
Okay, Nicholas Kaufman.
I do indeed thank Your Honours for that consideration. And we did, in fact, have a short version prepared and a long version prepared. So I'll be reading from the long version, and that was specifically so that we could accommodate the redactions that have been so insisted upon, and we respect that, of course, by the prosecution. So I now turn, with respect, Your Honours, to count 2. And this concerns the alleged murders of high-value targets during the presidential period. And before addressing the individual incidents that the prosecution characterizes as involving so-called high-value targets, the defense makes a preliminary observation. The term high-value target appears throughout the prosecution's brief as though it is evidence of a coordinated plan to eliminate targets. With respect, that inference cannot be sustained. The existence of a prioritization category within a law enforcement campaign does not establish a criminal plan. HVT was an operational classification used by law enforcement. And in this sense, it is no different from a similar acronym in another country where I have clients. APOTS, or Australian Priority Organisation Targets. HVT is not a code for an instruction to kill or a witch hunt. It was a prioritization tool within anti-drug operations applied across regions and units on the basis of intelligence assessments, alleged position within drug networks, or inclusion on watch lists. Classification does not imply selection for murder, any more than it is proof of unlawful intent. The prosecution itself acknowledges the existence of formal operational frameworks, including police circulars and structured campaigns. Within those structures, individuals could be designated high value for purposes of operational attention. Many HVT operations, in fact, resulted in arrest or surrender, albeit some resulted in fatal encounters. For this reason, each alleged HVD incident must be scrutinized on its own evidentiary foundation. When the incidents falling under count 2 are examined individually, the pattern we submit is similar to those incidents falling under count 1. Namely, heavy reliance on insider testimony, wishful and selective reading of police reports, and dubious and tenuous linkage to Rodrigo Duterte. Now, the operations cited under count 2 were conducted within the framework of the lawful war on drugs, and as such, operational contexts are consistent with planned law enforcement activity, including buy-bust operations and coordinated arrests rather than preordained killings. The evidence for count 2 incidents consistently shows that the deaths occurred during armed confrontations in which force was used in response to an imminent threat, in accordance with the rules of engagement repeatedly articulated by President Duterte, namely that lethal force was permissible only where life was in danger. Across the count 2 incidents, there exist contemporaneous documents, whether it be arrest warrants, operational records, or firearms recovery reports, all of which reflect legitimate police operations that escalated into exchanges of gunfire. The general record does not substantiate a theory of wanton execution, yet the prosecution seeks to rely, once again, on the testimony of criminals spilling their hearts with a tacit understanding that they will never be prosecuted. In 4 of the 5 incidents, contemporaneous reports document the recovery of firearms at the scene, indicating that the weapons were used against police and prompting a responsive use of force. In incidents 12, 13, and 14, the operations were authorized by judicially issued search warrants. We have diagrams on the screen being shown. I'm not going to stop. They will be presented throughout my presentation continuously.
There was, bago ipagpatuloy si Attorney Kaufman, para maintindihan niyo kung anong ginagawa niya, ipipresenta niya yung mga HBT na mga namatay, mga insidente kung saan may namatay. Kasama dyan si Kian de los Santos, kasama dyan yung 32 na namatay sa Bulacan, kasama dyan si Espinosa. Lahat po yun ay pinapakita niyan may police operations at may pinalabas na order na galing sa korte, kagaya ng search warrant. So yun sinasabi niya. So ibig sabihin, gusto niya ipakita dito na on record. So ang gusto niya ikukontrahin ang mga prosecution, mga kalaban ni Duterte ay parang naghula-hula lang, kwento-kwento lang. Sa kanya, puro papel ang kanyang pinipresenta. Okay, pakinggan po natin.
In an attempt to save time. Those circumstances are squarely within operational legality and fundamentally incompatible with a pre-planned murder. Incident 14 is particularly instructive. 4 individuals were arrested alive. To us, that demonstrates selective and not indiscriminate use of force. In incidents 10, 13, and 14, gunpowder residue was detected on the victim's hands. At a minimum, that forensic finding is consistent with an exchange of gunfire and not consistent with a straightforward execution narrative. And the prosecution and the victim's representatives simply can't have their cake and eat it. They can't say in one breath that drugs and guns were planted on victims and therefore dispute crime scene evidence. While
Kumbaga, ang kinokontra dito ni Kaufman, yung aligasyon ng kalaban ni Duterte na nagtatanim daw ng mga baril at kung mga droga. So, tingnan natin, pakinggan natin sa kanya. Ang sa kanya sinasabi, puro lahat nakapapel. Detalyado, may mga papel na kagaya ng search warrant na pinalabas ng Korte ng Pilipinas.
At the same time, complaining about the lack of crime scene evidence. Yet the prosecution virtually disregards these objective and forensic indicators in favor of narrow and often uncorroborated insider testimony.
So, ibig sabihin, meron daw silang insider's testimony, pero walang ibang testigo o walang ibang ebidensya na magpapakita na tama yung claim ng insider's testimony daw. Pag sinabi mo insiders, yan po ay mga kumbaga kasama sa paggawa ng krimen at sa testigo parang whistleblower ang dating. So tingnan natin, pakinggan po natin.
This is best illustrated in Incident 10, which rests almost entirely on P1160's assertion that a firearm was planted at the scene of the crime. And the official report
natin ngayon ng assertion na planted ang mga baril sa mga namatay.
Fabricated. Yet P1160 expressly accepts that he did not witness the planting of the firearm and merely
Tapos yung testigo nila na nagsasabi na planted ang baril ay si tahasan din niya sinabi na hindi niya nakita, hindi niya personal na nakita ang pagtanim ng baril.
Assumes that it must have happened before conceding that the firearm may already have been present. Once again, we are in the realm of inadmissible conjecture.
So, ibig sabihin na ang mga sinasabi doon ng nagsasabi na informante nila ay hindi matatanggap na ebidensya dahil nga wala siyang personal na alam kung talaga bang tinanim ang baril.
We know that an investigation followed that incident. The opening of an inquiry is not consistent with the intention to conceal wrongdoing. Beyond that, as I've just mentioned, the record reflects the detection of gunpowder residue on victims' hands in this particular incident.
So, pinpoint out na ni Kaufman na ang insidente na ito kinikwento niya. Ang problema lang natin ay binabawalan siya banggitin kung sino ang involved na tao, sino yung sa likod kasi may tinatawag na redacted. So ngayon, dito ay talagang kulang-kulang din ang ebidensya. Okay?
A forensic indicator consistent with an exchange of gunfire and inconsistent with the witness's testimony. Which is
may testigo ko na tinanim ang ebidensya at nagtestigo na pinatay ang tao na walang kalaban-laban, pero yung forensic evidence nagpapakita po, sa tingin ko iyan yung kay Espinosa, nagpapakita po na may gunpowder residue. Ibig sabihin, may ebidensya na mayroong tinatawag na pulbura na nakuha sa kabay ng biktima na baril. So malamang ito yung si Espinosa na tatay ni Kerwin.
Once again, uncorroborated. Incident 11. This is the sole incident in count 2.
So in short, sinasabi ni Attorney Kaufman, walang ibang ang testigo ay walang ibang testigo na magsasabi na totoong sinasabi ng testigo. Uncorroborated. Dapat may iba kasing ebidensya na magtugma doon sa kanilang sinasabi ng testigo ng prosecution.
Where direct linkage to Mr. Duterte is advanced. And this linkage rests entirely on voice recognition by an individual who claims to have overheard a telephone conversation and recognized the president's voice.
Okay, so ngayon may isang tao, na isang testigo na yun, nagsasabi, ang kanyang basihan na tumawag daw si Duterte. Ang sabi niya ay si Duterte yun kasi alam niya yung boses ay si Duterte. Pero kinlaro niya na hindi niya nakita si Duterte. Basta sinasabi niya lang, ang boses ay si Duterte daw.
While being physically moved from one location to another. The alleged recipient of the telephone call himself was never interviewed, and another person
So,
present,
yung sinasabi ng testigo ko no, na tumanggap ng telepono, ng tawag, ay hindi rin in-interview. So, that makes now the claim as doubtful.
on whom the prosecution relies for corroboration, did not hear the conversation. After all, would it not have been an item of interest to all those present in that specific location that the President of the Republic himself had condescended to discuss matters of such a criminal nature by way of telephone?
So, gusto palabasin, sabi ni Atty. Kaufman, hindi ka panipaniwala na gusto nila ilitrato na yung presidente ng Pilipinas, na presidente siya, ay bababa siya sa level ng mga operator sa tatawag siya.
So the ridiculous assertion stands solely on the word of one single individual.
So ang nagsasabi lang isang tao lang. Ay so ibig sabihin, pag isang tao, walang ibang testigo na mag-corroborate o magsuporta, ay ang punto ni Atty. Kaufman ay hindi mo magagamit na ebidensya para sabihin mo na si Digong Duterte ay nag-utos para pumatay.
Only other corroborating witness, the one who heard nothing, acknowledged a personal resentment that he harbored for the then president, Rodrigo Duterte, for reasons you will find in PHL OTP 000-16420-R01 at 0022, lines 695 to 708. Once again, I can't mention the reasons because it's redacted.
Okay, hindi na mabanggit kung sino yon, yung biktima o kung sino yung tumawag kasi redacted, ibig sabihin kinatago. Pero one thing is clear here, kung may kulang-kulang ang ebidensya ng prosecution laban kay Duterte, ganun po ang nakikita niya dito.
Voice recognition in uncontrolled conditions while being physically moved, and uncorroborated by any forensic or documentary evidence cannot constitute substantial grounds for confirmation, particularly where it forms the sole mechanism for attribution. Incident 12. This incident relies heavily on a central witness whose credibility is seriously compromised by retaliatory motives he admits to harboring against Mr. Duterte.
Yung insidente naman kasunod binabanggit niya, ang testigo ay galit kay Duterte. So, siniraise ni Atty. Kaufman, you can never rely on a person who is mad at Duterte and to rely on that person as telling the truth. Kasi nga, ulitin ko lang, galit siya kay Duterte. Kung sino man yan, hindi binabanggit ang pangalan kasi po ni-request ng judge na huwag banggitin ang mga pangalan kasi for security reasons.
Found in OTP tab 55 at page 27. Line and another reason that we cannot mention in open session. But which
by the way, mapapansin mo, mga sinasite po ni Atty. Kaufman, yun po yung mga ebidensya ng kalaban nila. So may sitwasyon kayo po na nakikita rito na ang ginagamit na ni Atty. Kaufman ay ebidensya ng prosecution laban sa prosecution. So, yan po ang nangyayari. So, ginagamit niya na bala laban sa prosecution ang sarili nilang ebidensya. So, pakinggan pa natin.
Can be found in PHL OTP 000-15167-R01 at page 0008. For this particular incident, the case record demonstrates that this operation was conducted pursuant to a judicially issued search warrant, with operational reports and documentation concerning the recovery of firearms. To display such an extensive contemporaneous record, one would expect the prosecution to produce forensic evidence capable of undermining the reliability of these materials. Evidence demonstrating fabrication or inconsistency sufficient to reduce their probative value. None, however, has been forwarded, because none presumably exists.
So, grabe ha.
Incident 13. This relates to the killing of Mayor Espinosa, whose name I can mention,
Espinosa naman.
and Raul Yap, who was shot in a police cell. The prosecution's case is largely premised on a witness who claimed to have heard but admitted not to have seen anything. Thus, there is nothing in the prosecution's
Ang testigo ng prosecution patungkol sa pagpatay kay Rolando Espinosa ay nagkiklaim na wala siya nakita.
Evidence to contradict the alternative theory proposed for this incident, which is that there was a firefight between the victims and the officers in the police station Leyte Sub-Provincial Jail. Nor is there a need to enter into these conflicting accounts because the prosecution's own evidence exculpates Rodrigo Duterte for responsibility for this incident. Not that he admits any connection to it. After all, according to the prosecution, on 1 August 2016, Rodrigo Duterte gave Espinosa a 24-hour ultimatum to surrender.
Okay, kasi kiniklaim niya na paano magiging si Duterte may connection sa pagpatay kay Rolando Espinosa kasi binigyan pa niya ng ultimatum nag-surrender. Parang gano'n. Alam mo, si Kaufman, mas magaling pa si Atty. Pelayo dyan. Kaibigan ko eh.
And surrender he did the following day. 4 days later, Rodrigo Duterte commended Espinosa for surrendering to Ronald De La Rosa.
Pagkatapos doon, sumurrender si Espinosa, pinuri pa ni Duterte si Espinosa at nung sumuko siya.
Commenting that it was just as well that he did. So if we look at it from the point of view of Rodrigo Duterte, that is where the incident ended, despite Mr. Jeremy exhorting us to believe otherwise. What happened thereafter, as awful as it may be, had nothing to do with our client, and not one witness can say that.
So, kung ano man nangyari kay Espinosa doon sa jail na napatay siya, walang kinalaman si Duterte. Yun ang argumento ni Kaufman.
The prosecution's narrative in Incident 14, the raid on the house of another person who I can mention, the mayor of
Ni-raid naman isang bahay. Tingnan kung sa anong insidente to.
Miss City, rests exclusively on a witness.
Kay Rinaldo Parohinog. Sa Osami City, yung namatay, ang si Joby Espinido ang ano dito. Ang bida.
Who, for reasons we cannot explain in open session, is wholly unable to provide complete or reliable testimony for reasons that can be found in D36, tab 181, lines 128 to 155, and lines 191 to 212. Contemporaneous documentary police reports reflect that this police operation proceeded pursuant to 6 judicial search warrants. Something hardly...
So, sabihin, ini-emphasize niya yung kay Osami City Mayor na si Rinaldo Parohinog, ang operation niya is may search warrant.
Consistent with a premeditated murder scheme.
So, kung search warrant, walang premeditated na papatayin siya. Walang plano na patayin siya.
If the intention was cold-blooded murder, why go to the bother of involving a judge? Official investigative materials also indicate that officers approached the premises, announced the execution of the warrant, and were met with gunfire that struck a patrol vehicle and injured an officer, prompting a return of fire.
So ngayon, kaya ina-argue dito ni Atty. Kaufman na walang kinalaman si Duterte dyan kasi nung sinerd daw nila ni Joby Espinido yung search warrant ay binaril sila kaya nag-retaliate sila.
This directly refutes what Ms. Masita so categorically claimed on Tuesday, namely that none of the arresting officers were ever harmed during the operations. Transcript. T5, page 44, line 24. In every case, the victim was killed, and none of the arresting officers were harmed. The exchange of fire, as reported, is supported by the fact that gunpowder residue was found on 7 individuals, including on the mayor himself and a paraffin test turned out positive on the person of one of the victims, indicating that he had discharged a firearm, something totally negating the gun plant theory proposed by the prosecution's.
So, may ebidensya na nagpaputok ng baril ito mga namatay dun sa bahay nila ni Parohinog.
Witness. It is also worth stressing that 4 individuals were arrested alive following the operation, and that one of them was subsequently sentenced to life imprisonment.
Tapos, kinlaro pa na 4 sa loob ng bahay, 4 ang inaresto na buhay, hindi pinatay. At yung isa dyan, ay sa tingin ko si Nova Parohinog ay nasentensyahan siya ng habang buhay na pagkabilanggo.
After the domestic courts rejected claims of evidence planting.
So, ibig sabihin, ang RTC na nagdesisyon ay hindi tinanggap ang kwento na pinatay sila yung mga kasama niya at yung sila ni Nova ay hindi tinanggap ang kwento niya na sila ay inaresto na wala daw silang droga nung inaresto sila. Pakinggan natin.
That fact alone is not consistent with a theory of indiscriminate execution, but is rather consistent instead with arrest and prosecution within the boundaries of the law and not indiscriminate use of force. So to summarize, across incidents 10 to 14, count 2, we see absolutely no evidence whatsoever of any attribution to Mr. Duterte on the granular level, nor do we see any evidence of a mutually agreed course of conduct on the upper hierarchical level of government involving Mr. Duterte and his alleged so-called co-perpetrators. The record reflects police operations conducted at unit level, sometimes under judicial warrant. P1166 describes...
So until here, sinasabi ni Kaufman, lahat may papel. Lahat may official records.
Operational discretion resting with the local team leaders and characterizes planned killings as rare and locally motivated. P1066 clarifies that to neutralize that word, which has been heard so often in the last few days, neutralize referred to lawful enforcement, not killing, the prosecution's own witness. The Senate committee report refers to rogue uniformed police. To conclude, the evidence reflects decentralization, not control required under indirect co-perpetration. And for these reasons, confirmation on count 2 cannot stand.
So, may papel lahat. Pagbigyan nyo na si Kwan, walang kwenta siya sabi ni Enzo sa ni Bad. Durog si Kaufman, kakahiya naman kayo kay Enzo.
I'm going to start count 3. We have until 10:30. I'm conscious of the time allotted to me. So count 3 relates to the barangay clearance operations during the presidential period. Incident 15 marks the beginning of the barangay clearance operations. Now, from this point forward, a familiar pattern emerges in the prosecution's narrative. The same modus operandi, to employ Mr. Jeremy's language, routine buy-bust operations are recast as sham exercises designed to conceal extrajudicial killings allegedly ordered from some unspecified source from above. Mr. Jeremy claims a target was identified through the use of lists. Well, there's nothing wrong with that. As one witness, an intelligence officer, explains in his testimony, the use of lists is a normal standard procedure. Once validation was conducted on a person, X, a file on that person would be created as a result of intelligence operations. Then, so claim Mr. Jeremy and Ms. Croft, the target is murdered and reports are falsified and rewards are paid out. This, Ms. Croft suggested at transcript 5, page 23, lines 11 to 13, is the systemicity of the pre-planned attack. But this is not the case. The defense can point to contemporaneous official records generated across different units or organizations.
Kumbaga, pinupuin natin dito lahat ng insidente na binabanggit, hindi lang nababanggit ang pangalan kasi binalaan si Attorney Kaufman na huwag magitin ng mga pangalan. Pero sa lahat ng binabanggit niya, pinipresenta niya yung official records. Base, ilalaban mo ngayon sa mga kwento ng mga sinasabi na insider info na kung titingnan niya, ay may tinatag na may pagpalagay ng presumption of regularity ang mga pulis. So paano tatalunin ng salita ng kuno ay whistleblower ang mga records? Yan ang pinopoint out ni Attorney Kaufman. At because of that, wala naman kasamang testigo pa, iba, walang mag-corroborate at walang, kaya ang pinopoint out niya mahina at hindi mo masasabi na at walang connection na si Duterte talaga ng papatay nung kung pinapatay man.
That show clearly that in the majority of these incidents, the evidence reflects legitimate law enforcement operations involving spontaneous and reported exchanges of fire and uses of force subjected to forensic and administrative review. These are not clandestine acts hidden from scrutiny, Madam President, but rather recorded operations consistent with self-defense in the course of policing. And where the evidentiary record supports competing inferences, including the inference of a lawful armed confrontation and the inference of an unlawful execution, well, and with this I will conclude, in dubio pro reo.
Ibig sabihin in dubio pro reo, ang mga lawful records dito makikita nyo ay kung hindi pa kayo maniniwala, may tinatawag na duda. At ang tawag ng duda na kung may duda, papabor sa akusado. Kaya sinasabi din, in dubio pro reo. Kung may doubt, may duda, pabor sa akusado. Thank you.
10:30.
Merci beaucoup.
Thank you very much, Mr. Kaufman. So I've understood that you would like to use the time that remains to you. And you have, you still have 20 minutes, actually. I understood that you wanted to use that time. Yes, I would, but I'm not so sure if I can conclude in 20 minutes.
Nous essaierons, Madame.
Ouais, donc vous avez...
Judge Moteg, well, it's still...
Across incidents 15 through 49, the Chamber will repeatedly encounter contemporaneous buy-bust or warrant-based documentation, reported exchanges of fire, gunshot residue findings, ballistic testing, immediate hospital transport, internal investigations, and in some cases, prosecution and conviction of officers. Against all of this evidence that you've just seen on the screen here, the prosecution offers single insider accounts of alleged stagings and corroborated assertions of weapons planting and nanlabans, unsupported by any forensic evidence, often speculative, frequently contradicted by the alleged co-participants, or yet, more often, complete silence from the alleged co-participants, as they were never even questioned about the incident. And most importantly, despite Mr. Jeremy's assertions on Tuesday, wherein he claimed that the police reports were repeatedly falsified to legitimate the operations as acts of self-defense, copy-paste reports in which victims were frequently blamed for their own deaths, there is zero proof, none, that the only existing contemporaneous documentary evidence is fabricated or unreliable. No proof whatsoever of this supposed falsification in the entire case record.
So walang pruweba na persipikado.
And on this point,
kaya may dahilan para mag-rely sa mga dokumento na magpapakita na walang kinalaman si Duterte. At walang pruweba ang mga prosecution na magpapakita na pinalsipikado o tinamper yung mga dokumento na pinalabas sa investigasyon sa mga namatay.
Just clarify a basic principle that a state document with the appropriate stamps and signatures and what have you is prima facie reliable, or in other words, it carries a presumption of administrative regularity. And if the prosecution seeks to displace that document and call the entire state apparatus into question, then the burden rests on it to produce credible, objective evidence rebutting that presumption.
Okay, kinlaro ni Attorney Kaufman na yung lahat ng dokumento ay may tinatawag na trabaho lamang. Presumption na maayos. At kung gusto nila na may prima facie evidence na maayos, at kung gusto ng mga prosecution na patunay na hindi maayos, ang problema nila, maghanap sila ng ebidensya at tumbahin nila. Ang obligasyon sa pagtutumba ng prima facie evidence na binibigay sa mga dokumento ay nasa kamay at mabigat sa balikat ng mga prosecutor.
Bare allegations or reliance on single prosecution witnesses cannot suffice to overcome.
Lumalabas dito, isang testigo lang pala. Isang tao ang bawat kaso na binabanggit nila, isang tao lang ginagamit nila para magsabi na yun ay tinatawag na AGK o di kaya extrajudicial killing. So ang tanong ni Kaufman dito, kung isang tao lang, sino pang iba na magsusuporta sa testimonya ng isang tao na ang mga papel na pinresenta ay may tinatawag na pinapalagay sa batas na totoo. By prima facie presumption po siya ang tawag dyan.
This presumption of authenticity and correctness, nor should the burden shift to the defense to prove that those documents are not falsified. Now, we do not deny that in some instances the record may reveal unlawful conduct by individual officers.
O yun ha, pinutol ha. Talagang pag si Kaufman ang nagrepresenta, pinuputol ang internet.
TP tab 108, in which the police proclaimed that 32 people were killed in Bulacan big-time operations, and then went on to refer to this as one single operation in which 32 victims were killed by the police in Bulacan. But what Mr. Jeremy failed to tell you,
Ang pinag-usapan ngayon, yung operation sa Bulacan na 32 ang patay.
Your Honours, is that one of the prosecution's own witnesses explained clearly that he investigated these deaths in an official capacity soon after the killings and found that 33 people were actually killed in different municipalities and provinces in central Luzon. But that their
Hindi sa isang lugar, different provinces and different places. Nangyari in 33 para hindi 32 na namatay.
bodies were delivered to Bulacan.
Sa Bulacan ang karamihan.
This was not, as Mr. Jeremy suggested, a single incident of mass murder.
According kanila, gusto palabasin ng prosecution, yung 32 o 33 na namatay, isang lugar lang daw yun, minasakir daw ni Duterte. Okay, lumalabas. Bali-bali. Iba-ibang lugar pa pangyayari yun. Nako.
But rather, an improper aggregate of a series of law enforcement operations over the course of 24 hours executed in large geographical area and for which we have no evidence in the case record. There's no evidence on the perpetrators, victims, motives, manner of attacks, methodology, in essence, nothing to link them to an alleged fantasy common plan. Everything is just stitched together enough to give it a veneer of organization. I now turn to incidents reflecting documented armed confrontations.
So lumalabas po, isang testigo lang pala gamit nila. So hindi mananaig laban sa may mga dokumentado. Mahirap. Ulitin ko lang, nandaya pang prosecution na sinasabi nila minasakir daw sa isang lugar lang yung 32 daw sa Bulacan na namatay. Hindi po, iba-ibang lugar na pinangyarihan. So ito, patuloy natin pakinggan.
And as mentioned when I first turned to this count, the documentary record, which has not been displaced by any evidence proffered by the prosecution, reflects attempted arrests, resistance, and responsive use of force. And you've just seen some of the documents up there on the screen.
Talaga nakikinig si Judge Muto ko. Talaga nakinig sila lahat. Ibig sabihin, interesting ang delivery ni Kaufman.
Let's turn briefly to Incident 17, for which the prosecution has relied on a witness who stated that the planting of evidence was an open secret in the locality and province more generally.
May isang testigo na pinag-bati-basyan na nagsasalita na common na daw yung pagtanim ng gun, ng ebidensya.
However, another witness working in the same locality, P1208, states otherwise, that he was never involved in illegal operations resulting in deaths, was not aware of extrajudicial
Pero may isang testigo pa nagsabi na hindi. Kinakontra.
Killings disguised as lawful operations, and confirms that there were no standing orders to kill. The operational objective, he explains, was arrest. Lethal force only when the circumstances required it. And you can find this information in Defense tab 96. And we see this pattern again and again and again. In Incident 40, for example, P1131, who worked with the individual alleged to have shot the suspect, stated clearly that the killings occurred only in circumstances of lawful use of self-defense. That can be found at Defense tab 74, and you can see it on the screen as well. This type of testimonial evidence is also corroborated by documentary and forensic evidence. Incident 15, the prosecution again resorts to its usual pro forma narrative of staged killings or nanlabans. But what it has not done, of course, is prove this. Whereas I urge your honors to look at the screen where you can see detailed documentary evidence about how this incident came about.
So you see, nakikita mo, ang ginagawa ni Kaufman, nilalaban niyang lahat ng mga papel na lumabas sa mga investigasyon. Kinontra niya yan laban sa mga kung sino na nagsasabi na siya ay tumitestigo, isang tao na wala man ang kasamang testigo pa isa para kontrahin yung mga papel na hindi totoo ang mga papel. So yan pinaka-problema ng prosecution. Hindi mo po pwede matutumba ang mga papel na sa pamamagitan ng isang testigo lamang.
And I summarize, a spontaneous exchange of fire after the suspect discharged a firearm, ballistics testing of the officer's weapon, affidavits by the police officers involved, and formal review and investigation of the officer who fired his weapon. Now, I'm not going to sit here and bore you with all the evidence we have on every single one of these incidents, but what I will tell you, Your Honours, is that we have this type of forensic evidence proving attempts, arrests, armed resistance, and responsive and sometimes disciplined use of force in no less than 13 incidents. I don't know where Mr. Butoyan got the idea from that there's no forensic evidence left in the case.
Tinira si Butoyan, si Joel Butoyan, na nagsabi na wala daw forensic evidence. Ito, pinapakita niyang forensic evidence. Lumalabas dito na sinungaling si Attorney Joel Butoyan.
And may we remind you, Your Honours, until the prosecution proves otherwise, which it has not, these state documents remain prima facie, authentic, and reliable.
Habang pag hindi nito mabaliktad, mapatunayan na ito ay hindi totoo, mananatili po na may prima facie evidence na matibay itong mga dokumentong ito. Kasama na yung mga forensic evidence na sinasabi ni Atty. Butoyan ay hindi daw nagkaroon.
For incidents substantiated by a single witness narrative and unconfirmed by alleged co-participants, I refer Your Honours to no less than 9 incidents. One prosecution witness, P1160, is the sole testimonial evidence for at least 3 incidents, while another 6 incidents are premised entirely on the testimony of P3. Now, what's interesting about these incidents is that P3 alleged that he was only one of a group of 3 or 4 perpetrators. And these other perpetrators are actually also prosecution witnesses. Yet none of the other witnesses corroborated his version of events. Not one.
Wala ba na
A couple of incidents alleged by the prosecution appear on its own evidence to be unrelated to drug enforcement and thus questionably part of the fantasy common plan or organizational policy. For this, I would refer you to incidents 31 and 41, which involved targeting of 2 individuals, again, because of non-drugs related conduct. I'm not sure whether I can mention the type of conduct without revealing the identity, so I shall refrain from doing so. The prosecution has not presented any evidence to substantiate any nexus to anti-drug operations in either of these incidents. And for this, I refer you to D36, tab 158, at page 4. On the perpetrator's own account, the trigger for the killing was a personal grievance relating to property damage. There are numerous incidents against unidentified or improperly identified victims. The victim in incident 45 is described as a minor, just as in incident 38, another incident on which Mr. Jeremy focused on Tuesday. And by the way, on the subject of the killing of children, of course, it ticks the right boxes for the prosecution insofar as it pulls the heartstrings. But apart from Kian de los Santos, the prosecution has not, despite its emphasis on children, presented to this chamber during these proceedings any evidence that even one victim, apart from Kian, in its 49 incidents was a minor. No birth certificates, no corroborative evidence, nothing. While incidents presented as involving minors are indeed grave, Article 61 requires proof, not emotion. It is for the prosecution to prove that the children were involved in these incidents, and not for the defense, once again, to prove a negative. Now, this evidentiary deficit extends even further. The Bulacan Provincial Office provided a certificate indicating that it had no record corresponding to the names of the victims, whose names have been redacted on the slide, which we will show you. Okay, but we'll pass on.
Actually, yung kay Kian de los Santos, ebidensya pabor kay Duterte yun kasi nagpapatunay na hindi pa baya si Duterte at nasintensyahan yung mga 3 pulis na pumatay kay Kian de los Santos.
But the names have been redacted. And these are alleged police killings, yet no operational report. Indeed, no contemporaneous documentation whatsoever has been produced. So on what does the prosecution base its claim that these individuals were murdered by the police other than P3? The prosecution relies almost exclusively on the account of P3 echoed by P8. And this is rather ironic. Does the prosecutor claim that P3 is corroborated by P8 when the source of P8's information is in fact P3 himself? Bootstrapping logic, once again. The alleged direct perpetrator, P1201, stated during his interview that he had never participated in an operation involving a child. The other officer allegedly present during both incidents, P1131, was never questioned about these events by the prosecution. And that admission, we submit, is not neutral.
So, ang nangyari dito, na-stop na naman, ang nangyari dito ay kulang-kulang talaga ebidensya pala nila.
Quite clearly, fall outside of that plan. And it does not reflect what the prosecution on Tuesday described as the systematic features of a national network operation. Instead, according to P3, the motive was personal financial gain through the sale of bodies. And if P3's account is accepted, it reflects opportunistic actions for personal gain of the most macabre kind. As held in Al-Hassan, an opportunistic act committed for personal profit without more falls outside the common plan. Now, just to finish up quickly on the issue of identity, in incident 43, even the alleged perpetrators are not identified. Without identification, the Chamber cannot assess their institutional affiliation, chain of command, or attempt to make any possible linkage to Mr. Duterte. One more thing, Your Honours. The prosecution focused for some time on incident 23. I can mention his name, Mr. Benjamin Vizda. Mr. Jeremy displayed compelling footage of Mr. Vizda's arrest and then...
Oy, pinutol na naman, oh. Grabe talaga si BBM, oh. Pinutol na ba nga? Ay, naku.
What happened when Mr. Vizda was taken away on the motorcycle. The fact that while handcuffed, he attempted to grab the gun of one of the policemen, leading to a struggle and prompting the motorbike to fall over and the policeman to shoot Mr. Vizda twice in self-defense. And that this PNP report appears to be corroborated by another prosecution witness, whose testimony fully aligns with the substance of the police document. Mr. Jeremy claimed that the PNP reports were false, relying solely on the allegation of one witness that the scene was staged. This witness claimed that the handcuffs were removed from the victim, that the body was loaded on the tricycle a few minutes after being shot and then brought to the hospital. However, his account is contradicted by the very picture the prosecution has shown you on Tuesday.
Kini-claim na, handcuff, may handcuff, tapos, pero ang picture na pinapresent nila, kumontra sa kanilang alegasyon.
Indeed, it appears that the prosecution is submitting documentary evidence which undermines its own witness's testimony. As you can see here,
Sita sila ng picture na kumontra sa testimonya ng kanilang testigo.
Handcuffs are on. The body is on the...
Tayo, may posas. Oh, hindi siya sabi na tinanggal ang posas. Hindi, ayan ang litrato, may posas.
Ground rather than on a tricycle. Photojournalists are also present. This contradiction was even noted by the prosecution's investigators at the time of the interview and was put to the witness. And when confronted by the investigators, what did that witness say? I don't know if I can...
O yan, pinutol na naman. Grabe.
Satisfied. And finally, with regard to count 3, the prosecution's witnesses themselves concede that there was no formal approval process. Targets were selected without validation, officers acted for personal reasons, and decisions were taken locally. All of this destroys the assertion that there was a mutually agreed common plan. I will elaborate. P1160 claims hierarchical transmission of policy within the police, while simultaneously acknowledging officers' autonomous killings for personal motives. Those propositions cannot comfortably coexist. P3 explains that certain officers acted outside any common plan and for opportunistic reasons. See Incident 38. In Incident 49, P1207 attributes instructions to local officers without evidence of communication or direction from higher authorities. And most significantly, P1207 P1207 states after a certain death, once again abiding by the redactions, Tokhang operations and killings ceased. This indicates, Madam President, Your Honours, that dependence on specific individuals, not an enduring organizational policy. A system-wide common plan cannot depend on the continued presence of a non-fungible local official.
Okay.
And with this, I conclude.
Okay. Palakpak, bravo, bravo, kupan, bravo, bravo, bravo. Patay na. Wala na. Tiwas na kung sa mga Cebuano pa, tiwas. Hindi ka pa naman mga Brian Rodriguez, kita nyo na ha. Ang galing. So hanggang dyan na, kakain muna tayo. Babalik ako. Kakain muna tayo. Paki-like, paki-share at paki-join sa aking channel, mag-membership kayo, ay 75 pesos a month. Tapos kung may sobra kayo, paki-Gcash na naman ako. At saka kung mayroon kayong pang palipad, bigyan nyo naman ako ng super sticker. Ito po ang aking Gcash number. Ang aking pangalan ay ito. Okay? Magandang gabi. Kakain mo na si Tirador.